In 1980, Congress passed a law establishing a system of withdrawal liability for underfunded multiemployer pension plans. As a result of the bills bouncing back and forth between House and Senate during the legislative process, the Finnish statute contained an exception for the trucking industry. In Continental Can versus Chicago truck drivers, the Seventh Circuit pondered one employer's effort to use comments in the Congressional Record to persuade the court that the trucking exception applied to it. In the first half of the 1980s, Continental Can Company employed truck drivers to transport its goods in the Chicago area. As part of its agreement with the truck drivers' union, Continental paid pension contributions to the Chicago Truck Drivers Pension Fund. Continental closed its trucking operation in 1985 and withdrew from the pension fund. The federal statute required employers to fully fund their share of pension funds unless, quote, substantially all, unquote, of the contributions required under the plan were made by employers primarily engaged in the trucking industry. The fund demanded that Continental pay its shortfall, which was about $700,000. Continental protested that it fell within the trucking industry exception. An arbitrator determined that substantially all meant at least 85%. Because only about 60% of the fund's assets were attributable to employers primarily engaged in trucking, he ruled that the law didn't apply and ordered Continental to pay up. Continental asked a federal district court to set aside this award. Continental claimed that the legislative history of the statute showed that substantially all meant 50.1%, and that it was therefore exempt from the payment requirement. It argued that the words of a statute were merely evidence of the legislator's intent, and that this intent provided true meaning of the law. The court disagreed and upheld the arbitrator's award. Continental Can appealed to the Seventh Circuit.